We'll recognize Vice Chair Veet on the substitute. It has been circulated. We sent that out yesterday. It's my understanding the sponsor and Vice Chair Veet have been working on a substitute with a one-word amendment clarification. Representative Veet, you're recognized.
House Committee substitute. House Committee substitute was after we discussed the bill and went through it. I will tell you there is one of the sections where we're dealing with public utilities yet. What is a public or utility?
Representative Veet, are you offering the House Committee substitute?
Yes, 030626H 08C. I move for its adoption.
Is that the correct number?
Ending in .08.
Ending in .08C?
Yes.
Is that the one we're talking about?
Yes.
All right, please proceed.
After discussion, we met and discussed this bill and heard some of the issues that individuals had. I will tell you that there's going to be a slight change before it reaches the floor, which will limit this to investor-owned utilities. It will not be applying to any of the municipal utilities, co-ops, et cetera. This bill has a few different changes. It changed just compensation for farmland to 150% of fair market value. It's added another provisions that, as you know, in condemnation law, when they file a petition to condemn land, they have to have said they have made a good faith offer. Well, what this bill says that if you get a judgment that is more than a good faith offer, then you can collect attorney's fees. And that's going to really make a lot of cases settle because they then will be forced to make a good faith offer. And contrary to popular belief, 98% of America does not want to be in a courtroom. And most farmers and people don't want a courtroom. And if they're made a good faith offer, taking everything to consider, I think this will be good for the utility companies and the landowners. And if they're not going to make a good faith offer and force the landowner to hire an attorney and defend it, which they don't get compensated for, the landowner will never be made whole because all the award is for fair market value. So that was one of the amendments. We did change a little bit about the commissioners. There was some language in there about the previous commissioners being county commissioners and things of that nature. And after doing some more research, it was pretty clear you could not do that. And what we have put in there is a county commissioner, one being a farmer and the rest of it the judge will still appoint. And I think that covers most of the changes.
All right. It's also my understanding, Representative, that you had a technical amendment to that substitute.
I do, and I would move to offer amendment .01H, and that was changing the word court determination to judgment. Just to clarify, the original bill had jury in. That wasn't correct. What is a court determination can be not clear. We all know what the courts have recognized the word judgment. So I move for the adoption of amendment adding in .01H.
All right. The representative moved that House Committee Amendment 1 to House Committee Substitute, is that the correct procedure? Be adopted using the formal term judgment. Discussion on that amendment first. Representative Coleman.
Mr. Chairman, may I ask a question about the underlying substitute, or is that inappropriate at this time?
Sure, go ahead. We'll get to it sooner or later anyhow.
Thank you, Mr. Chairman. Mr. Vice Chairman, can you tell me a little bit about why you moved the section from applying just to merchant lines to all utilities?
That is one of the issues that's going to have to be corrected in the amendment so that it's only going to apply to investor-owned utilities, and the merchant line, when it gets cleared up, will be, it's a difference between a line application or territorial application, and so ultimately it's going to be mainly just to the line applications.
So my understanding is that there's going to be a floor amendment to clean that up to make sure it's applying back to merchant lines, not everybody?
to the extent, and I have talked with the with the utilities, and I think that's what we can do. There were some questions whether we were allowed to do that, but I think that's what the ultimate goal is.
I think that kind of segues into my follow-up question. Was that done as an attempt to exempt the co-ops?
Well, I think when you look at the definition of the utilities, and there are several statutes. We were looking at 386.020, and there's another statute was that most of these utilities are investor-owned, will be limited to just investor-owned co-ops, investor-owned utilities. This bill ultimately will not only exempt out co-ops, it will exempt out municipal utilities too.
What's the public policy justification for treating those differently?
They're all non-for-profit.
Okay. So your intent,
You're condemning land by a non-for-profit. It's a little different than when you have an investor-owned utility is going to be condemning land for profit.
okay, so you did intend then to bring in the other utilities, not just the merchant lines. Okay, thank you. I appreciate the clarification.
And Representative, I'm not quite sure. I know you have an amendment. I'm not going to ignore that. I'm not sure which in the order properly that should be, but
I think we have to vote on this amendment, and then I'll be able to offer my amendment.
okay. All right. Go right ahead, Representative Davis.
Thank you, Mr. Chairman. Vice Chair Veet, I assume the bill sponsor is favorable to this amendment?
Yes, these amendments have been made with his input and with other individuals' input, yes.
Okay, thank you.
And just to clarify, Representative Veet, you've actually had some live experience over the years in this particular area in condemnation, eminent domain. And you sat down, to my knowledge, with the bill sponsor to talk about some issues.
I sat down with him, went through the issues with them. I sat down with other parties that had an interest in this, and we made a lot of changes that they had just because I've tried a lot of condemnation cases, and I've seen the, and understood the technicalities that we had to overcome.
Further discussion of the amendment to the House Committee substitute. Just want to get on the same page. Seeing none, all those in favor of adopting the word change, the House Committee Amendment number 1, signify by saying aye. Aye. And opposed, no. The ayes do have it. The amendment is adopted. Further discussion on the House Committee substitute. Representative Coleman, go right ahead.
Thank you, Mr. Chairman. I have an amendment ending in .02H, which has been distributed. And this provides, I just want to say, I want to thank the continuing conversation about this eminent domain reform is desperately needed in my community, and people are really frustrated about it. And I have voted in the past against this reform because it's not, in my opinion, real reform. It's attempt to on one project rather than address the entire system of problems. So this is an attempt to kind of continue that. I'm suggesting that we are eliminating the section that would give a veto power to county commissions. That concerns me. I think that if the PSC is granted approval and the local communities are represented, that's not an appropriate thing to do. And the other thing that this amendment does that's significant is it make sure that this is going forward only when we're setting public policy. Retroactively, that creates a constitutional problem and invites litigation. And so I want to make sure if we're making good public policy changes, we're doing that moving forward and not interfering with contractual rights of existing projects. So with that, I'm open to any questions.
And Representative Coleman, were you moving for adoption of that amendment?
Yes, Mr. Chairman.
All right. Further discussion.
May I inquire?
Go ahead.
I think the underlying substitute amendment we filed, everyone concedes, has a date in there of August the 22nd of 2022, and it's your version of it is a little bit different terminology, but I think when you look at it, it is going to exempt out those that already have easements or doing construction, and so the existing one that everyone's in discussion, and I'm not the Supreme Court, so I don't know.
We seem to negotiate against them a lot, don't we?
I think that this bill will address that. I also, on your bill, you put the state of Missouri as commissioners from the state versus the county.
That's right.
You realize that that will require some other statutory changes because the statutes require they come from the county.
Correct. I understand that there's some changes that would need to be, just like the underlying amendment, maybe cleaned up on the floor.
Chair has just a couple quick comments. It is I always try to talk to folks about amendments and talk to the sponsors about amendments and see their position. The sponsor of this bill is not yet comfortable in agreeing to this amendment. He indicates he has for several years been working with folks on amendments, has not yet had the opportunity to sit down and discuss this amendment. At this time, he believes it may in fact be detrimental to the intent of his bill, and that's helping farmers and protecting the rights of citizens of the state of Missouri. And it's my understanding he would be certainly willing after today to sit down and discuss those issues further with the amendment maker, but at this point he does oppose the amendment. So further discussion by the committee.
Can we have a roll call vote, please, on the amendment?
Sure, I don't have a problem with that. It's not normal procedure, but we'll, Madam Clerk, on the amendment as requested, special request, please call roll.
Evans,
Nay.
Beat,
Pass.
Ellabrock, Anderson.
No.
Coleman,
Yes.
Davis, Mackey, Reedy, Riley, Sauls, Schroer, Veet,
No.
Davis,
I'm sorry, I didn't hear. The amendment has failed by a vote of 6-3. Now we move to the House Committee substitute. Do I have that right? We move to roll the amendment number 1 into the House Committee substitute and to adopt the substitute. And it is a voice vote unless otherwise ordered or requested. All those in favor indicate by saying aye. Aye. And those opposed, nay. The ayes do have it. And now we take the final vote. I now renew my motion to do pass House Committee substitute for House Bill 1876. Now further discussion on the House Committee substitute as amended. Any further discussion at this time? Seeing none, Madam Clerk, please call the roll.
Evans,
Aye.
Veet,
Aye.
Ellabrock, Anderson, Coleman, Davis, Mackey, Reedy, Riley, Sauls, Schroer.
By your vote of 5 ayes, 4 noes, you voted House Committee substitute for House Bill 1876 do pass. We'll move now to a bill sponsored by, I think, Representative, yes, House Bill 1861. I move that House Bill 1861 be voted do pass. The bill submitted by Representative Eggleston. Discussion on that bill. Seeing none, Madam Clerk, please call the roll.
Evans,
Aye.
Veet,
Aye.
Ellabrock, Anderson, Coleman, Davis, Mackey, Reedy, Riley, Sauls, Schroer, Coleman, Davis.
By your vote of 8 ayes, 1 no, you voted House Bill 1861 do pass. Okay, then directly to House Bill 1641, sponsored by Representative Coleman. I move that House Bill 1641 be voted do pass. Further discussion at this time. I see a hand. Representative Riley, please proceed.
Thank you, Mr. Chair. I have an amendment ending in .01H. It has been distributed, and I move for its adoption.
Discussion, first explanation and then discussion by the committee.
Sure. So what this amendment does is it removes the first portion of House Bill 1641, which deals with conscientious objections to vaccine mandates. I know a lot of us on the committee have some heartburn over those provisions in particular, to the extent they have a large impact on private employers and seem to potentially be government telling private businesses what to do and substituting our judgment for the judgment of private business owners. So this removes that portion of the bill and it leaves the liability portion in place.
All right, and you discussed this with me before. For the record, you've in fact discussed this with the bill sponsor?
Yeah, that's correct, and thank you for reminding me. So I'm offering this amendment on behalf of the bill sponsor, who obviously does not sit on this committee and is unable to offer that amendment himself.
All right, further discussion by the committee. Representative Coleman.
Thank you, Mr. Chairman. I just wanted to say what Representative Riley just did, which is that this is not my bill, that this is Representative Coleman's bill. Thank you.
And the chair will admit to, I had a 10-minute conversation earlier this year with Representative Coleman on our committee thinking it was her bill.
And I played along because it was an important first conversation about our time together.
It was an embarrassing discussion. Further discussion. Representative Davis.
Thank you, Mr. Chair. And I just wanted to also add that we have passed language which would allow for the conscientious objections in other bills with tighter language. So I'm in favor of this amendment. Thank you.
Thank you. Further discussion. On the amendment. Further discussion on the amendment. All right. Seeing none, all those in favor of adopting House Committee Amendment 1 signify by saying aye. Aye. Opposed, no. The ayes have it. You've adopted the amendment. I now move to row House Committee Amendment number 1 into a new House Committee substitute and to adopt the substitute. All those in favor signify by saying aye. Aye. And no opposed by saying no. The ayes have it. You've adopted the substitute. And I now move that House Committee substitute for House Bill 1641 be voted to pass. Discussion now on the substitute as amended. Representative Veet, Vice Chair.
Again, I have concerns on the substitute in that it leaves unlimited liability exposures to the employer. It doesn't limit it to workers' comp. It doesn't have any limits, and I think it would be just not feasible for an employer to be unlimited liability. And we have other bills out there that have been passed and approved that will address it, limiting it to workers' compensation benefits. Thank you.
All right, thank you, Representative Veet, and I've taken a fairly broad position on these with the charge to each member. We've had, I think, going on now 28 COVID bills in this committee, that each representative that's presenting a bill would need to talk to other members of the committee and see if they had sufficient votes. That I would, as a general rule, pass bills along for debate if there was sufficient support. Further discussion on House Bill 1641, or pardon me, on the rolling it into the amendment. Do pass. I now move that House Committee substitute for House Bill 1641 be voted do pass. By Madam Clerk, call the roll.
Evans.
Aye.
Veet.
No.
Ellabrock. Anderson. Coleman. Davis. Mackey. Reedy. Riley. Sauls. Schroer. Coleman.
By your vote of 9-2, you have voted House Committee substitute for House Bill 1641 do pass. Now moving on to House Bill 2093, I move that House Bill 2093 be voted do pass. Discussion, again, it's my understanding, Representative Riley, you have an amendment.
Thank you, Mr. Chair. I have an amendment ending in .04H. It has been distributed, and I move for its adoption.
Go ahead and explain it, then we'll open it up to the committee for further discussion.
Very good. So as the committee may recall, there was some confusion during the committee a couple weeks ago when we heard this bill about what the exact intent was. And speaking with the bill sponsor, and as he indicated in committee, his intent with this bill was to limit government entities from enacting vaccine mandates. He had no intent to deal with private sector employers and what they may choose to do in the workplace. So this amendment, in working with the sponsor of the bill on the language, clarifies the intent of the bill and is stating that we're just focusing on government entities and prohibiting them from enacting vaccine mandates in the state.
And again, just to clarify, he approves your amendment as you've drafted.
Yes, sir, he does.
Further discussion by committee. Representative Mackey. It's the hair is the only difference I can see. I don't know. I'm sorry. The tie, different colored tie. I've done that twice now. Once you weren't here, once you are here. It's okay to embarrass the chair. Representative El Brock, ranking minority member, go right ahead.
Sorry. Does this amendment take out the sunset provision there at line 3? The provisions of this section shall expire January 1, or does it keep that in?
No, you are correct. It removes the sunset, so there's no longer a sunset in this bill.
Okay, so does this remain compliant with the Supreme Court, the United States Supreme Court rulings on healthcare workers and people that can reasonably be required to get a vaccine, with the exception of religious exemptions?
I believe it does. There wouldn't be anything in this bill that I'm aware of that would prohibit healthcare facilities from complying with that federal mandate.
Okay. I mean, it's just a really narrow line we're trying to shoot here.
Agreed.
Between, like, making sure that people aren't required to get a vaccine if it's not absolutely required, but the people that do work in, like, nursing homes and hospitals and stuff, that they can still be, like, because that's what this is about, right?
Yeah,
So
that's right. You and I are in agreement on that. I tried to craft this in a way such that it wouldn't bump up against that issue.
Okay. Thank you. Thank you, Mr. Chair.
All right. Ranking minority member, thank you. Vice Chair, just use titles from now on. It'll be easier for me.
To inquire
Go right
the
ahead.
maker, to inquire the maker of the amendment.
Sure.
Just so I'm clarify this for me. This means if a government employee, state hospital, and there's a federal mandate that they do certain things, does this bill says that we can't enforce it, or what does it do to those people? If they have to comply with CMS and these other rules, how does this affect on them?
Do we have any state hospitals?
Well, University of Missouri, Truman. There's a lot of state hospitals when you get down to it.
So if we have state hospitals,
and they're dealing with their what you call agreements, say that they will comply with the federal rules, and the federal rules say employees have to have vaccination. Just assuming that. What does this do to them?
so I would say if we do have state-owned or operated hospitals, then we would probably need to do a little cleanup language, which I'm certainly open to working on. I'll work with the bill sponsor on that because, again, I don't want to end up in an issue where we are in conflict with that CMS mandate, and now we have a Supreme Court opinion that upheld that mandate. So I would say that we will need to tweak this a little bit more before it would go to the floor for a final vote.
Thank you.
Further discussion of the amendment? Yes. Representative Sauls, go right ahead.
Thank you. Just to kind of express some concerns with that too, I think I understand what you're trying to do, but I do think there will be some additional concerns. I'd also trying to put my JAG hat on, and I don't know about like guard and reserve type issues, what that would do here either. So I think there are probably some other things we need to work on before, or at least that needs to be a topic of conversation. At least that's my concern. Thank you.
All right, further discussion. All right, seeing none, all those in favor of adopting House Committee Amendment 1 signify by saying aye. Aye. Opposed, nay. The ayes have it. You've adopted the amendment. I now move to row House Committee Amendment 1 into a now new House Committee substitute to adopt the substitute. All those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. You've adopted the substitute. I now move the House Committee substitute for House Bill 2093 be voted do pass. Discussion now on the House Committee substitute as amended. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Beat? Ellabrock? Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Thrower? Ellabrock? Davis? Thrower?
By your vote of 7 ayes, 4 noes, you've voted do pass House Bill 2093. House Committee substitute for House Bill 2093. Now move to House Bill 1475. I've moved that it be voted do pass. Discussion on that bill. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Ellabrock? Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Thrower? Veet?
That's 1475, correct? And that's 8-3. By your vote of 8 ayes, 3 noes, you voted House Bill 1475 do pass. Now moving to House Bill 1624, I move that it be voted do pass. Discussion on that bill. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Ellabrock? Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Thrower? Coleman? Davis?
By your vote of 7 ayes, 4 noes, you voted House Bill 1624 do pass. All right, in just a second, we're going to go into public hearing on 4 bills tonight. I apologize. I also have a bill to present in the committee next door. They're waiting on me, perhaps, right now. So I'm going to turn the chair over to Vice Chair Rudy Veit. And the ranking minority member will be sharing the chair duties as Representative Veit presents his bill later down the road. So I'll try to get back as soon as I can, but I'm heading next door. Representative Veit.
Which bill is it? Just push.
Which bill is it?
You tell me.
Which is the first one?
1547 is the first one I have up. We'll now proceed with House Bill 1547, sponsored by Representative Veit. Please proceed when you're ready, Representative Veit.
Mr. Chairman, my name is Rudy Veit. I'm representative 59th District. I'm here presenting House Bill 1547. This bill has been through the committees, I think, for the third time. And basically what it does, right now we have a lot of people that are on pretrial release and otherwise have shackles put on so we know where they're at and where we can keep contact with them. If you take a hammer to your shackle and knock it off or something, that is a crime. But since the new shackles came out, you don't need to do that anymore. You just fail to charge them. And if you fail to charge them, then they lose contact. So the deputies have to go out and look for you, and that's the time when they can do the things they probably shouldn't do. The batteries on these things are long batteries. I think they're 14 hours, and you're given, I think, 3 sets, and it gives you warnings not if they're running low, so you don't accidentally just run one low. And this is a problem. We don't want people committing crimes while they're out on shackles and doing something, so the next person may not get that same opportunity. We have, if you are released on a felony and you fail to keep it charged and a violation, and the court finds it's intentional, it's another Class C felony. But if you're on release for a misdemeanor, it is still another misdemeanor. This bill is brought to me by several circuit judges and by some officers who are in the pretrial release, and it is a frustrating experience for them to have to go track down people. And the more concern is that the acts they do during this time period is going to jeopardize the whole system. You know, when we have one person does something bad on bond and on release, it jeopardizes the abilities to give that opportunity to other people. With that, Your Honor, Your Honor, Mr. Chairman.
You can do that. That's fine. I'll take it.
Mr. Chairman, I'm open to questions.
I'll start with a couple of questions that I have. Do you have any idea how much the electronic monitoring equipment costs per unit?
You know, I apologize. I had those people here last year and the year before, and today I thought I didn't know it, but I know it's more than hundreds of dollars, the whole units, because they have complete tracking device on you, and you have a box.
Sure.
They have to travel.
And I'm not trying to drag this out. You're an attorney. I'm an attorney. We both kind of know what we're talking about here. The question is directed at whether or not we know these units cost more than $500 to already qualify as felony property damage, and whether or not we can charge for that. Because my only question is, why are we charging these people with a felony for just not charging their battery? I mean,
because it may not do any damage to the property. That's all it does. You just recharge it.
I understand that, but most of the time when these things happen, it's because they've damaged the property, and you get them on felony property damage if the thing's in value of excess of $500.
That's what this deal was with the old ankle bracelets. They didn't have batteries. These have batteries, and they now know that, so they just don't charge them. There's no need to destroy one because you just don't charge it, and it doesn't work. And that's their concern, is that this is the opportunity for them to commit crimes. It's a challenge to our police department, our sheriff's department to track it down, try to find them where they're at. You call them on their cell phone. They may not be in an area where a cell phone is off or cell phone's not working, and that creates its own set of problems. So the concern wasn't about the hurting the, and if they take a hammer to it and beat it up or something, destroy it, that probably is a separate crime. But this is not, this causes it no harm. It's just, that's the neatness of it. They just don't charge it.
I understand your perspective. I'm just curious to know why a new felony is required.
Because there is no property damage if they just don't charge it. It doesn't hurt it.
So it'd be, essentially, this is tantamount to felony failing to charge a battery.
Yes, but that's the purpose of it is else only if you're out on release of it's
Sure.
a Class C felony,
Sure.
regardless of what felony you're out on.
Why can't it be a misdemeanor to fail to charge a battery?
Well, I guess if someone is out on a felony warrant and we're given the opportunity of pretrial release, we have a greater interest in making sure that they understand the significance of what their release is and that they honor it and don't go out and commit other felonies while the battery's down.
All right. Those are my questions. Is there any other? Are there any other questions from the bill sponsor? Representative, what name shall I make up for you, Representative Sauls?
Whatever you want.
I'm just trying to fit the bill. Go ahead.
All right, thanks. Your honor works too, if you want to, you can pass that this way. As
Your
well.
honor.
Okay,
Carry on.
Thank you. Good afternoon. A couple things I was just thinking about. So while I understand the intent here, and I don't think I think there's room for something like this. I'd also, I mean, there, for example, there are some felonies that I don't necessarily think would, I mean, like driving while revoked, for example, is a felony. Driving while revoked is, I don't know that warrants another felony for something like failure to charge the device, such as, now, there would be circumstances that would, I would think, but go ahead.
I understand that, but that's part of the problem is, and I didn't bring them here to testify, but there's an elaborate system where they get warnings many hours ahead of time. They have other batteries that are going with it. And so you don't just inadvertently fail to charge your battery. It's not, and I think intentionally moves, alters, intent is in there.
Well, I don't,
It fails to charge. So it's not just mere negligence. It's in there that they fail.
okay.
And that was one of the things we discussed last year. It's not just that they failed to charge and I forgot to charge my battery. That could happen to anybody. This does require the intent finding.
And that was going to be my suggestion was going to be putting knowingly or something to that effect. But now that you mentioned that, I do see.
Well, I think it was made at your suggestion last year.
Right. Well, that's probably makes sense.
And I appreciate that because that's what
Right.
they have these hearings. But if I'm open to suggestions. I'm not married to this bill.
Sure.
It is the only way to do it. But I do recognize the problems. And I do know that back when I did criminal law, if a judge gave somebody a break and that guy breached that trust of the judge, the next time the judge would be more likely not to give the guy the same break. And so we don't want to have judges being concerned about, well, I let him out on shackles, he doesn't charge it, he commits another crime, and people, what that does to the public.
Right. Okay. Thank you.
Any further questions of the bill sponsor? Seeing none. Is there anyone here here to testify in favor of House Bill 1547? Is there anyone here to testify in favor of House Bill 1547? Seeing none. Is there anyone here to testify in opposition to House Bill 1547? Anyone here to testify in opposition? Seeing none. Is there anyone here to testify for informational purposes only on House Bill 1547? Seeing none, that concludes our public hearing on House Bill 1547. We will now open to hear House Bill 1548. Representative Veet.
Mr. Chairman, my name is Rudy Veet, 59th District, and I'm here bringing to you House Bill 1548. And I first like to explain what the problem is or why it causes concern. A capital murder trial can run anywhere to the county 150 or 50 to 150 to 200,000. And this bill addresses the problem we have on change of venue cases, on capital murder cases. A lot of counties do not have the facilities and everything needed to handle a capital murder case. Those cases are then transferred to places like, say, Mobley, Jeff City, Columbia. And when those cases are sent here, the expenses of the capital murder case have to be paid. And there are many expenses. Like I said, it can be 150, 200,000 time you put all the security involved, the hotels, additional jurors that have to be brought in, the food, and that you have to keep them keep them in a hotel over the weekends and things of that nature, the cost can be substantial. Under the present law, you take that and you send it to the county where the case arose from, and they're supposed to pay you. We have a lot of counties in this state right now that have a population of less than 10,000 people. They don't have the money to pay back. So the burden is falling upon Cole County or the county that it's sent to. More importantly is, there's another angle to look at. If you are a prosecutor in a small county and you're going to have a capital murder case, you're more inclined to take an offer they plead guilty to something rather than trial, because the $150,000 to $200,000 can bankrupt the county. This provision sets forth that in these cases we would set up a fund, would be funded by the state, and we've only, whatever we decided to put in, the state did, it would be divided pro rata if there's more counties that had the issue than what the money was appropriated. That would give us a starting point. As I recall, and I apologize, we limited also in here what all we would recover. We didn't recover everything. It's mainly the cost of the jurors and the reimbursement of the juror costs and maintaining the jurors was the main thing we were recovering. Our court administrative thing, that was not going to be considered as a cost. So basically, we're a 2-minute warning, right? Okay. The bottom line is that it is not fair for the counties who are willing to, they don't have a choice but to accept these change of venues, for that burden to be dumped upon that county because there are a lot of counties that the change of venues come from. It's not going to affect the big cities and that because they all can handle their murder cases. It's all of these rural counties out here that do have small populations. They don't have hotel facilities. They don't have all the other things needed to do a capital murder case. And we want to make sure that if someone is charged in Clark County and does a crime, that his crime should be treated the same as someone who's charged with the crime in St. Louis, where it's not an issue, where they can afford to do a capital murder case. So that's the second point of it, is that if you commit a crime and it's the same type of crime, it ought to be treated equally in both counties. Thank you.
All right. Representative Eat, you brought this bill before the committee last year, and I remember I'm pretty sure it was a well-received bill last year. I can't remember
They all
any
made
votes.
it to
Yeah.
Actually, we're all on a bill at the Senate, but just died.
Right. There haven't been any substantive changes from the bill you filed last year that
No.
I think passed, if not unanimously, pretty close to unanimous. Is that right?
Yes.
Okay. So do any of the committee members have questions for the bill sponsor? Representative Sauls.
Yes, thank you. Just one quick question. Do you happen to know the amount of cases per year that are change of venue to Cole County, for example?
And there again, last year, and I apologize, but I didn't bring all the judges back up here, but I think last year there was 3.
Okay.
And again, this isn't, all this is really asking is for the cost of sequestering the jurors.
Right.
The extra bailiffs and that we can live with, but I mean, and Cole County is not that large of a county. $100,000 does mean a lot to us.
Sure. Yeah, I supported the bill in the past. I'm sure I'll support it this time. Just was curious, that's all. Thank you.
Any further questions from the committee? Seeing none, are there any people here to testify in support of the bill?
Oh.
Please remember to fill out a witness form.
Yes, thank you. Very briefly, Brian Burnskater here on behalf of Cole County. I just want to go and support. The representative did a great job of outlining the situation.
Are there any questions for Mr. Burnskater?
Thank you so much.
Seeing none. Thank you for your testimony. Any other people here who wish to testify in support of House Bill 1548? Seeing none, are there any individuals here who wish to testify in opposition to House Bill 1548? Please proceed.
Thank you. Good evening, Judiciary Committee. Thank you so much for the opportunity to testify. My name is Elise Max. I am Executive Director of Missourians for Alternatives to the Death Penalty. So obviously we are against the death penalty in all situations. But I really appreciate the opportunity to talk about this bill. I've had great conversations about the cost of the death penalty, because of this legislation. And one thing that we agree on is that the death penalty is expensive. And what's being presented today, we believe, is a Band-Aid approach. It doesn't address the problems with the entire system. In fact, Missouri has never done a full study about the cost of the death penalty. So to take public taxpayer dollars and create a fund to cover the cost of sequestering jurors, it raises a lot of questions about the system and why we need to use taxpayer dollars. Because Missourians care about the death penalty, they care about the return on investment of these public safety dollars. There's a lot of them that go into the system. The Legislative Oversight and Research Committee did a small program evaluation over the summer. They looked at 10 capital cases. They compared, one of the cases was the case of Eric Lawson in St. Louis County, where 2 times the Attorney General tried to sequester a death-qualified jury. They called in over 3,400 people in St. Louis City. The first time, they were not able to seat the jury. It was a mistrial. The second time, they were able to seat a jury. That jury cost was about $13,000 specifically for the juries. That case cost close to $200,000. In Jackson County, you have the same case you can compare to 3 counts of first-degree murder. The death penalty was never imposed. It was never imposed by the prosecutor. That case cost $5,000. So we have 2 people that are in jail on life without parole that have now cost hundreds of thousands of dollars because of the need to impose the death penalty. The jury question is important. It's real. No jury in Missouri has recommended death since 2013. And so to put the Band-Aid on this piece, to get these jurors in, to give these death sentences, it seems like an approach that isn't going to work. I did include in my written testimony, we looked at all of the change of venue cases in 2021. We know there were 17 pending capital cases and 8 of those were change of venue. So I'll include that information on where those venue changes happened, as well as the last death sentence was in January of 2018. And there have been no death sentences since then, and so we also looked at what those outcomes were. So I think that this is appropriate to talk about this expensive public safety program, but I would hate for us to put a Band-Aid on one piece of the problem without allowing for real research and real robust conversation about what this is costing taxpayers, what is our return on investment of this public safety program. Thank you for the opportunity.
Just in under the wire. Thank you.
Did I?
Yeah. Ma'am, please remember to fill out a witness form. Are there any questions for this witness from the committee? Seeing none. Thank you for your testimony in opposition, ma'am. Are there any other individuals here who wish to testify in opposition to House Bill 1548? Please remember to fill out a witness form and state your name for the committee and for the record, please.
Mr. Chair, members of the committee, my name is Donita Patterson-Brown, and I am a Missouri State Conference NAACP member, and I'm also the VA committee chair. I am also the secretary for the Pulaski County branch NAACP branch. I'm also a retired military member. I am here on behalf of Nimrod Chapel Jr. The NAACP of Missouri is unequivocal in the belief that the death penalty is cruel and unusual punishment. And its administration is rife with errors that violates the 8th and 14th Amendments of the Constitution. We stand in opposition of HB 1548, which creates a public fund for a piece of the death penalty system. It is unfair to ask the taxpayers of Missouri to pitch in when Missouri has never done a cost study on the death penalty, which the prior speaker has stated. There is no reliable evidence that the death penalty deters people from committing crimes. In fact, murder rates are higher in states that have capital punishment than they are in states without it. At the same time, the death penalty drains resources from the legal system, prisons, and law enforcement. Contrary to popular belief, The death penalty is much more expensive than the sentence of life without parole. This is a conversation we should have and are not throwing a Band-Aid on a broken system. Prosecutor discretion already defines which defendants face the death penalty. Prosecutorial discretion already defines which defendants face the death penalty and becomes prosecutors apply their discretion in vastly different ways. This has resulted in large geographical disparities in the rates of death penalty prosecutions and convictions in Missouri. Paying back counties for juries to change a venue, capital cases, does nothing to ensure that we are applying the ultimate punishment in a fair and equitable manner. To some, the Missouri State Conference of the NAACP opposes HB 1548. No public fund should be created to preserve the antiquated and racial practices of executing people, especially when Missouri has never invested in studying the cost of the death penalty. And that's signed Nimrod Chappell, Jr.
Thank you for your testimony, ma'am. Are there any questions for this witness from the panel? Seeing none, thank you for your time here, ma'am. Are there any other individuals here who wish to testify in opposition to House Bill 1548? Seeing none, are there any individuals here who wish to testify for informational purposes only for House Bill 1548? Are there any individuals who wish to testify for informational purposes only? Seeing none, that concludes the public hearing on House Bill 1548. I relinquish the chair to the vice chair. You want me to go ahead? All right. What's the next one? All right. We will now hear House Bill 1699, sponsored by Representative Roberts. Please proceed when you are ready, Representative Roberts.
Thank you, Mr. Chair. Good afternoon, members of the committee. Lane Roberts, House District 161, here to present House Bill 1699. This bill deals with elements of our current domestic violence statutes and offers about a half dozen amendments or changes to that law or additions. I'll deal with them one at a time. I do want to see this, that I understand that this is a very difficult session. We may not get a lot of legislation passed. However, when we're talking about domestic violence, the product that we deliver has real meaning to real people today. And so recognizing that for those victims, there is a sense of urgency that some of these things occur. And so it's still my hope that given that situation and the quality of their life, that we can do something to actually make this become a reality. I'll deal with the changes in this bill one at a time. The first change you will find on page 3. This bill says that service of the petition and notice of the date set forth for the hearing on such petition and any ex parte order of protection shall constitute legal notice of any orders issued by the court on the date of the hearing and any subsequent orders. This is important because when someone petitions for an ex parte, they have to be served 3 days in advance, which means from the time that the victim has the courage to come forward and ask for some protection, there's 3 days when under current law, the abuser is not subject to any of those conditions. And a police officer cannot enforce those conditions. And so you would have a new event that would not be subject to these limitations. Secondly, on page 4, you'll note that it says that the court may order a party to pay a reasonable amount to the other party for attorney's fees incurred prior to the commencement of any proceeding throughout the proceeding and after the entry of judgment. Currently, it would appear that, from what I know of the system, that it is only those costs associated prior to the proceeding that people are paying. There is no law apparently recognized that requires someone to pay throughout the proceeding. And this is a question of equity, and I think it kind of speaks for itself. And then on page 6, The third provision, number 9, in cases in which the respondent has been properly served with an ex parte order of protection, but fails to appear in court on the date and time set forth in the ex parte order for the full order of protection, the respondent shall be considered to have knowledge of any conditions set forth in the subsequent full order of protection issued by the judge at the time. And there's further language. What is occurring today is that when someone is given notice that there will be a hearing and they deliberately don't show up for the hearing, under current law, we seem to believe that that's a defense when they violate the order and then claim ignorance. They knew nothing about it. And so they're free until we collar them again to go on abusing the victim or violating the order of protection because they claim not to have known about it. And in too many cases, that's deliberate. This provision does have some issues that we are concerned with. I've been working with the chair and the vice chair of this committee to make sure that we address those concerns. But it's a very real concern. It happens far too frequently. On that same page, under number 10, the court shall not compel a victim or a member of the victim's family testifying in a criminal proceeding for a violation of these sections to disclose any residential address or place of employment on the record in open court unless the court finds disclosure to be necessary. I think everybody can probably recognize the need for this. When somebody goes on record, abusers come in a variety of seriousness, and in some cases, it exposes these individuals who do have the courage to come forward to additional risk for their families, their children, and their own person. And then on page 7, a person may testify by video conference at a criminal trial involving an offense under these sections if the person testifying is the victim of the offense. The circuit court and associate circuit court judges for each court shall develop the rules and instructions for appearances by video conference permitted under this subsection, which shall be posted on the circuit court's internet website. I know that on this committee there are former prosecutors, defense lawyers, and so you're familiar a bit with what the dynamic goes on. Too frequently, charges are dismissed because the victim doesn't appear in court. And the reality is it's not that they're afraid to come to court. It's not that they're afraid to be grilled by the attorney. It's that they're afraid to be in the same room with the abuser. And when that abuser is going to be in that hearing, and she has, or he, in most cases she, but either one, that abuser knows when and where they're going to be. And many times these victims actually develop tactical plans so they can get in and out of the building safely because the abuser knows where they are. And so being in the same room with them is a level of intimidation that those of us who've never been victims of domestic violence simply can't identify with. We can try, and many of us have better ideas than others, but the reality is it is an experience unique to people who've actually been victimized, particularly those who have those really serious offenses. And at the bottom of that page, if a judge orders a person who has been convicted of an offense under these sections to attend any domestic violence-related class, the person shall be financially responsible for any costs associated with attending that class. There is likely to be an amendment forthcoming regarding that to cross-reference another chapter under the law. There are two provisions here that I've not dealt with that are going to require some work. One is a provision that prohibits a plea bargain, which is probably not manageable. And the second has to do with payment to a domestic violence shelter. And there may be some work that has to be done there to make sure that that is something that's both legal and constitutional. And with that, Mr. Chair, I'll be happy to take any questions.
All right. Thank you, Representative Roberts, for bringing this important piece of legislation before the committee. I've been working with the chair and the vice chair on these meetings and discussing some of the issues that have come up on this, so I know that you're more than willing to work on some of the things that do have to be kind of worked over before this thing is ready for prime time, so to speak, before we can bring it to the floor. Having acknowledged your willingness to work with us in some of the areas that we have discussed with you that might need to be reworked. Are there any questions for the bill sponsor from the committee? Representative Sauls.
I'll be brief. I do also appreciate what you're trying to do. I think I think these bills are important. That being said, I do think there are some concerns I have, particularly I think you've got issues with Crawford, confrontation clause, things of that nature with regard to somebody being testifying via a Zoom or something to that effect. I think that would be a concern. Also with
Representative Sauls, I'm
Yep.
sorry. Would you mind speaking into the microphone? This is being,
sorry,
right, sorry.
thank you. Could you hear that? I presume.
I think I heard, but you had some reference to the video conferencing.
Yes. So Crawford and the confrontation clause. I think that's one of the problems you would have with regard to someone testifying not being present. I think there would be,
That is a concern that I did have some discussions about, and I would just for the sake of consideration, the process involved in issuing a protection order is a civil process, not a criminal process, and it is not unusual for people to testify in camera, like at arraignments, that sort of thing, where you have long distances involved.
correct.
And I think because this is a civil process, that this is probably acceptable and certainly caters to the safety of the victim and their willingness to testify.
Okay, and I think because it changes statutes a couple different times, and there's obviously talking about criminal statutes in here as well. So perhaps if that's the case, then that's my fault. That's correct. Crawford v. Washington, that's a criminal case. So perhaps I just saw that in this part. No plea bargains as well. I think, is your intent there to do an open plea then, or what would that be? What would that?
I think our intent there was to make sure that the abuser was held strictly accountable. Frankly, Representative, I think maybe our enthusiasm outran our common sense there, and it may be that we're simply going to have to strike that. I understand it's really problematic for prosecutors, and I recognize that. It's not my intent here to make things difficult.
Okay, and I appreciate that as well. Okay, I think we could probably talk offline about some of the other stuff, but I do appreciate your willingness to bring it, as well as your willingness to work to make, as the chair indicated, make it ready for prime time. So I appreciate that.
Thank you, Representative.
Thank you.
Any other questions for the bill sponsor? Seeing none, are there any individuals here today who wish to testify in support of House Bill 1699?
Yes, I submitted my witness form online. Jennifer Carter Duckler, I'm the Public Policy Director for the Missouri Coalition Against Domestic and Sexual Violence. So, yep. Great, so the Missouri Coalition represents the domestic violence shelters and rape crisis centers in the state, and I'm going to focus my comments due to time on the things that we brought forward to Representative Roberts that we're very appreciative that he included in his bill. We obviously support the whole bill, but I'm going to focus comments on what we brought forward. We're also supportive of the idea of having no plea bargains taken out, as well as some of the technical difficulties figuring out how to do a payment to a domestic violence shelter. We would be okay with not having that included and really focusing on what we could have some strong language for. So my husband is a law enforcement officer of 23 years, and when he was first trained, the intent of our ex parte language was that if somebody was served an ex parte and they did not show up for the full order, that they could still enforce the full order. Then we had something called Judiciary versus the state, which said, no, you cannot do that, that until somebody is served the full order, that is not in effect. And so this we are incredibly appreciative of, because as Representative Roberts said, what we often see is the respondent is served the ex parte, and then they don't show up for the full order, and it becomes a safety risk for survivors, and law enforcement are unable to hold somebody accountable to the full order provisions. I did want to explain the amendment suggestion for the domestic violence class and payment. A little over a decade ago, there was a domestic violence task force of the Attorney General, In it, we created a statute so Department of Corrections oversees the credentialing of what we call batter intervention programs in the state. So we would like, rather than it saying domestic violence related class under 595.320, we'd like it to cross-reference the 455.549 batter intervention program to make it really clear what that person should be paying for. We're also very appreciative of covering the attorney fees. That was also something there was a case law about that a very smart attorney figured out, well, the statute said I could still request not this part of the proceeding. And so the intent of the law was that attorney fees for any part of the proceeding could be requested. And so we'd like to make that clear. There's one other item that's not included in this, but Representative Roberts said I could go ahead and discuss it in case there was hope for an amendment, whether it's on the floor or in committee. Also, that in that Attorney General's task force, my husband was a domestic violence detective at the time, and he testified to an issue that we currently have with bond conditions. So when somebody is on probation for a domestic violence offense and there is a no contact order as part of the bond condition, law enforcement can be looking at that individual violating it and they cannot make an arrest on site. They have to go do an arrest warrant. There are other states that have passed laws like Tennessee, and I've talked to folks in Tennessee and they said it goes over very, very well with law enforcement and survivors and the advocate community, where law enforcement has the ability to arrest on site in those situations, and we would love to move that forward.
Thank you very much for your testimony, ma'am, and thank you for keeping it timely. You did seem like you were kind of running up against the end of the time. Is there anything else you would like to add?
Very appreciative for Representative Roberts and all the other support. This really does help address what might seem like small and insignificant, but really big barriers for survivors. And so very appreciative that he's really committed to wanting to move those forward. And again, I'd be happy to take any questions. If there are anything about the bond conditions, that continues to be something I hear from law enforcement as an issue, particularly for domestic violence, and how they can hold perpetrators accountable with that.
Sure. Are there any other questions for this witness? Seeing none. Thank you for your testimony here today, ma'am. Any other witnesses in support of House Bill 1699? Witnesses in support of House Bill 1699? Seeing none. Does anyone here today wish to testify in opposition to House Bill 1699? And if so, why? Is there anyone here that wishes to testify in opposition to House Bill 1699? Seeing none, is there anyone here who wishes to testify for informational purposes only to House Bill 1699? Anyone here to testify for informational purposes only? Seeing none, that concludes the public hearing on House Bill 1699. We'll now begin a public hearing for House Bill 2246, presented by Representative Copeland. Representative Copeland, House Bill 2246, you may proceed when you are ready. Thank you.
Thank you, Mr. Chair.
Just a reminder about the times, 5 minutes for you.
I got you.
3 minutes for every subsequent witness. You'll get the countdown. And then 3 for the last 3 is 30 seconds, just so you know.
Thank you, Mr. Chair. Just to let you know, my name's Representative Copeland, 143rd District. I was law enforcement for 28 years, so when this came to my attention, I thought it might need to be addressed a little bit. And to start this off, my goal on this is public safety and law enforcement resources, kind of what we're going to affect on this. And basically what this bill is doing is kind of giving some guidelines on bail when someone gets arrested and goes forward. And what happened in 2019, I guess the Supreme Court had ruled on some cases of non-monetary first conditioners of a non-monetary conditions of a pretrial release. And I think what's happened since that court case is that the judges have put that as a priority when releasing people on bail. And I think, and I got some examples of some OR releases since that time. And I feel that maybe some of this should be addressed as far as public safety and some of the concerns be put forward as the danger to the society should be put prior to the fiscal responsibility of the person being put on bail and the flight risk of the individual. And that kind of goes over on some of the felony charges and violent misdemeanor and sex offenses. This does not in any way take the discretion away from a judge when they're setting bail. It's just trying to correct some of the ruling that the Missouri Supreme Court did in 2019, putting a monetary value or monetary fiscal part as part of bail. First off, I'm sorry. I talked to the chair prior to this about speaking to the committee substitute. Do you guys have a copy of the committee substitute? I think you do, right? Okay, I want to make sure that he said that was appropriate, because the first bill I've worked with some people on, and I got copies of the committee substitute if you don't have that. Do you have that? Did they not pass it out? It's just a one-pager. Excuse me, I forgot to ask that portion first. And is that okay to speak to this committee sub? But basically, it just simplifies it. Some of the language in the first bill that was filed at the beginning was, I talked to some people, and it seemed to be a little controversial as far as the constitutionality of it. But basically, what I brought this bill forward to kind of explain and have a guidelines for the judges to say, we need to look at the public safety first, then the flight risk, and we just need to look at the overall safety. And being in law enforcement, another issue that concerns is, when they do set a bail, if it's an OR bail and they don't show up, the law enforcement has to go spend resources. If they are let on bail, then a bail issues, they would have to take on that responsibility, and it would relieve the law enforcement officers from having to actually run them down and bring them back to court. But I will take any questions. That's kind of the basics of this bill, and I'm more than happy to take some questions.
All right,
concerns.
Representative Copeland, thank you for bringing the bill forward. So just by way of clarification, the original bill that we're looking at starts with, notwithstanding any provision of law or court rule, the following shall apply when a judge or judicial officer sets bail in all courts in Missouri. Now, the committee sub that has been distributed already, that we're discussing currently as though it were the bill already, even though it hasn't been adopted, but likely might be, says notwithstanding any provision of law or court rule to the contrary.
Yes.
Which allows for the constitutional protections that the United States federal government and our state Supreme Courts require courts to consider in addition to these factors. Is that correct?
Yes, I think they probably consider these, but I think with what's happened with the ruling in 2019, some of the priorities have been put into the financial part, and I feel that maybe they need to put emphasis on the safety of the public, which they already probably are supposed to do, but I'm just trying to clarify that portion as well, the constitutionality, and that's whatever is and is required by law. Whatever is required by law, I'm just asking that to be considered.
Certainly. Thank you for bringing the bill forward. Are there any other questions for this sponsor? Representative Veet.
Just so that those who haven't seen the amendment, it is 4865H.02C, correct?
Yes.
So everybody knows which one we're talking about. Thank you.
Any other questions from the committee? Representative Sauls.
I'll be brief. Yes, so actually I prefer this bill to this bill. I think there were some other problems, not just constitutional, but some others with, and that is your intent. This is what we intend to
Yeah, after looking at it and reviewing it with some other issues in the chair, we come to the conclusion that some of these things might not be good for the overall reasoning and why we're putting this forward.
Yep.
So yes.
Okay. Well, I do think, for the most part, I do think this is better. The only complaint I do have, I don't know that I like the part about any felony offense within the last 5 years. I think there are situations in which I think that would be certainly something to consider. There are also situations where, like, for example, I just mentioned a felony failure to, dang it, not failure to appear. I just did it a second ago.
Driving while revoked. Driving while revoked.
Felony driving while revoked is one of those things that I've always kind of had issues with. I don't know that, I mean, my personal stance is I don't necessarily believe that should
And I'm willing to work with that, and I think in the upper ones, it might be a violent felony, you know, put
Okay.
into that kind of thing, you know, that kind of wordage as well. I mean, because there are bad check felonies, you know, are they going to come back
Sure.
and appear in court? That's part of the risk. Are they a violent offender on them issues? And I'm trying to address the public safety issue of it. And the judge still has the ability to put them on a
Sure.
ankle bracelet, you know, instead of the financial responsibility, if that's the case, you know. But I'm just looking at the public safety part of it.
I understand. And also, you know, what would be deemed to be, you know, I think it's argumentative as to what is a violent misdemeanor and what's not, potentially.
I agree. I did consider putting in specifics on that,
Okay.
but then when you start putting in specifics, you don't want to forget one, and then the judge still has that ability to make that discretion. I'm not taking that away from the judge.
Okay.
I'm just trying to clarify that, you know, when you put when you look at the financial part, are you looking at the overall safety of the citizens, or are you looking at the person being charged about they can't afford it? Maybe, but they still can look at the financial part
Okay.
along with that.
Okay, well, like I said, I do think this is a much better one. I'm sure we'll have an opportunity to talk a little bit about it offline, and hopefully we can get somewhere with that. I appreciate it. Thank you.
Are there any other questions from the committee for the bill sponsor? Seeing none. Any individuals who wish to testify in support of House Bill 2246, please come forward.
Thank you, Mr. Chairman, members of the committee. Sean Rhodes, registered lobbyist for Missouri Sheriffs United, which is the lobbying arm of the Missouri Sheriffs Association. We go on record in support. I did glance at the sub. We're good.
All right. Is that all?
Yeah, I'll make
All
it
right.
quick. You got 3 minutes. We got time. It's 5:30.
Are there any
Let's go.
questions from the committee? Seeing none. Thank you for your testimony here today.
Also, to add to it, if I could, Mr. Chairman, and to answer Representative Saul's question, and I know Chairman of the committee aren't they able to issue on a felony driving while revoked a summons still? Can they do that?
Yes, they can.
That's what I thought.
Are there any further questions from the committee?
Thank you, Mr. Chairman.
Seeing none. Any other individuals who wish to testify in support of House Bill 2246, please approach.
Good evening. For the record, James Harris, representing the American Bail Coalition, here to go on the record in support. I think this is a good step in the right direction. I think the Supreme Court rule a few years ago created some uncertainty, and we've seen kind of an increase in OR bonds, and we are seeing kind of an increase in failure to reappear in many circuits around the state. And you also have a certain group of individuals committing crime that have probably figured this out. I'll give an example. I read a case in St. Charles about a month ago where it was the individual's third time for stealing a vehicle. First 2 times, the individual was apprehended in St. Louis County, released on OR bonds both times. The third time, the individual was apprehended in Charles County before they crossed the river, and the judge chose not to do an OR bond on the third time. But, you know, when someone is committing multiple crimes, not returning to court, they have, I would say, gone from low risk to high risk, and the use of OR bonds in that situation should be used less. With that, I'm happy to answer any questions.
Thank you, Mr. Harris. Please be sure to fill out a witness form. Are there any questions for the witness? Seeing none, thank you for your testimony here today. Are there any other witnesses here to testify in support of House Bill 2246?
Mr. Chairman, members of the committee, my name is Brent Hemphill. I'm here with the Coalition of Surety Agents of Missouri. We want to go on record in support of the bill. You've heard all of the testimony, and I think this is a continuation from last year. I think the bill is a step in the right direction to try to give and empower judges to make those determinations that what is public safety, the ability to pay, and the crime that they're being charged with. So we think it is a step in the right direction.
Thank you for your testimony, Mr. Hempel. Be sure that you have one. All right. Are there any questions for this witness from the panel? Seeing none, thank you for your testimony here today. Are there any other witnesses here to testify in support of House Bill 2246? Seeing none, are there any witnesses here today to testify in opposition to House Bill 2246? Please approach, ma'am. Again, the same rules apply. You have 3 minutes for your primary testimony, and then the committee will be entitled to ask questions.
Yeah.
Thank you.
I am Peggy Placer, and I'm here to testify against the bill. I'm a volunteer with the RMF Community Bail Fund in Boone County. We are an all-volunteer nonprofit organization funded by community donations, and we have great community support, and people were shocked to hear how this bill might affect us. We pay 100% of bail up to $3,000 for Boone County residents with Boone County charges detained before trial in our jail. Our average bail for 2021 was around $1,300, and most of you being attorneys know that's very low. So we are looking at people with minor charges, often misdemeanors. Yet the people we bail out or their families cannot afford to pay that or even 10% to a bail bond agent. They would be held for weeks, punished before trial. If we bail them out, we provide information about court, reminders of court dates, and sometimes rides to the courthouse. Over 90% appear because they know when their case is completed, we receive a partial refund, which gives them a sense of meaning and helps us continue. HB 2246 would make it very difficult for us to operate if I'm understanding the terms of the bill. It would establish a presumption against release on one's own recognizance, which would be based on the judge's discernment. We don't see that many of them, contrary to prior reports. Or an, quote, unsecured bond for pretrial detainees under certain conditions. Bail bond agents, as you know, take 10% fee from defendants or their families for, quote, secured bonds, and thus would not be affected by these conditions. They could still bond out anyone who could pay, even people with very serious charges. I check the jail's daily report and see this repeatedly. Thus, the bill discriminates against us because we are an unsecured bail fund. We are especially concerned about two conditions in the bill. More than one failure to appear in the past 3 years. In 2021, we bailed out 26 people out of 69 total who failed to appear on a misdemeanor charge. Maybe an officer just gave them a summons to appear because their charge was so minor. When they did not appear, they received a warrant, were picked up and jailed. They do not pose a danger to the community that would warrant detention. We give them another chance by bailing them out and helping them get to court and back to their lives, and it works. Another one is convicted of a prior felony in the past 5 years. We may have bailed out people with such convictions. We don't check. We figure that they have paid the price for that conviction, and we only consider the current charge. People should not be held in jail for a traffic charge because they were convicted of a felony years ago. That does not make sense. This seems like an invitation to a lawsuit, but I'm not an attorney. And once again, a bail bond agent would be able to bond them out anyhow. We ask that you consider what this bill really does. It is not a bill to reduce crime. It is a bill to support the interests with the stake in incarceration. It will contribute to more jail overcrowding and more taxpayer expenses on jails. We are small, but we have saved Boone County thousands in jail costs just since 2019. Jail time costs people their jobs, housing, and contact with families. Those are the collateral costs. We know many in the General Assembly, some in law enforcement, and bail bond agents opposed the Missouri Supreme Court order. Punishing us, and more importantly, our clients, is not the answer. They're poor. We do not intend to raise money forever to pay a ransom to get poor people out of jail, however. We want something better. Work with us to make our communities safer by funding treatment, shelter, diversion, and other proven ways to make our communities safer that do not entail jail. Until then, please do not support HB 2246.
Thank you for your testimony here today, ma'am. Appreciate you coming out. Are there any questions for this witness from the committee? Seeing none. Thank you for your testimony here today, ma'am. Are there any other witnesses who wish to testify in opposition to House Bill 2246? Are there any other witnesses who wish to testify in opposition to House Bill 2246? Seeing none, that concludes the public hearing on House Bill, informational purposes only. Ooh, I almost dropped the ball on that one. Anybody here to testify for informational purposes only? I know, you give me one shot. You can't even get my name right. That's all right. Anybody here to testify for informational purposes only? Anybody here to testify for informational purposes only? Seeing none, that concludes the public hearing on House Bill 2246. That also concludes the hearing today for the Judiciary Committee. Thanks. We are adjourned.